Proceed with this. This is what Diane and I do pretty much every day is appeals. Claims procedures and the right to appeal. Okay, so we've got kind of a diagram here, and let's just take a look at this. I'm going to talk to you a little bit about legacy appeals. Now, there are two appeal systems happening right now with VA. I want to teach you about legacy appeals because there's still, I think, something like under 500,000 legacy appeals still active in the system, and we're still filing them, quite frankly, and I'll tell you about those. But the laws were amended, and on February 19, 2019, the new appellate process came into being. They call it the AMA, the Appeals Management Act, and it basically gives 3 lanes, one of which is actually an appeals route. The other 2 are really adjudicative routes, and we'll talk in depth about that as we go. But I want to show you the legacy process. I've been at this in this state about 14 years. I love this appeals process. It works. I've seen hundreds and hundreds of people get their benefits when they were just flatly denied. And through this fact-finding process, this is an appellate process with fact-finding. And to my mind, it's the best fact-finding that I know of in any court. Now we've got VA Regional Office Initial Claim. So that's filing a claim for compensation. We use a 526EZ to do that. It's a form. What if there's a denial? Then you've got this process in the old system, which still exists for maybe another year or 2. Decision Review Officer. That's basically an administrative law judge. They don't call him that. They call him a DRO, Decision Review Officer. And that individual takes a fresh look at the whole case. They can actually send out for evidence. They can develop the case any way they see fit. It's a lot of discretion, just the way an appeals court judge has at the BVA, the Board of Veterans' Appeals level. That's the way I solve a lot of cases. Now, ultimately, if the decision review officer does not find for my client, they'll issue what they call a statement of the case, a big packet citing all the laws applicable, and you've got 60 days to file a VA Form 9 to the Board of Veterans' Appeals. That's where we win the majority of our cases, Diane and I. Now, if the BVA doesn't do what we think is right and we've got a basis, you can go for a motion for reconsideration. I've actually won one of these, and one of my colleagues, Nancy Schubert-Uro, has also won one. They're kind of hard to win, but it is possible. Let's say you look for a motion for reconsideration. It gives you a little bit of time as well. You've got to get ready to go to the Court of Appeals for Veterans Claims. Diane's going to talk to you a little about that, I think. That's the next level after BVA, and of course there are more after that. And I'll just leave it to that. This is really the area we're going to focus in on today for legacy appeals. Okay. Now, here's the new appeals process. Okay, it's faster, it's perhaps more efficient. It also has some subtleties, maybe a little bit less opportunity for the facts to come out. In this appeals process, the judge does not have any power on her own or his own to send the case out for development, to say, you know, I think there were some mistakes in this case. I'm gonna have VA personnel develop this. The burden is on the advocate now, really, to argue that VA didn't do its job and show why indeed they failed in their duty to assist. And we're going to talk a little more about that as we go. So we've got this 3-lane process. We've got the higher level review, we've got the supplemental claim, and we've got the appeal to Board of Veterans' Appeals. We're going to look at all 3 of those in the 3 lanes. That's what I typically call this system. So that's just to kind of give you a kind of opening salvo in terms of the 2 systems. Legacy is the decision review officer, statement of the case if you got a denial, and a Form 9 to the board. That's the old-fashioned appeal route. This is the new one. So any client that you get who's got a decision after February 19 of 2019, they're going to be part of this process. Okay, so now I want to begin by the initial claims. You might well take a claim as a lawyer. It's more likely that a VSO would take the claims. But I think it's really important that you understand the claims process, because if you don't, everything else is nonsense, right, Diane? So it's really important that you understand how this benefits process works so that you can effectively apply this knowledge into your appellate work, which probably be the lion's share of the work for attorneys. First claim for benefits after service. By the time a vet reaches you, most vets, as attorneys, most vets have filed a claim before. When they left service, say most recent, last 15 years, members attended an exit program, they call it a TAP program, where they were given assistance with their first disability claim. That may and may not have been good advice at the TAP program, depending on the VSOs in attendance and what they actually did for them. So an initial claim for benefits, they're going to use what we call a Form 526EZ. It's a basic form spelling out what problems you've got that you think are service connected. Claims for increased rating. Now, a claim for an increased rating would mean you're already rated. What if you're rated 10% for both knees and the knees are progressively getting worse? And the veteran's doctor says, I think you're going to have some surgery down the road. Those knees are just getting worse and worse. If you've got objective evidence, your advocate can file a claim for increased rating for you. So you got a service condition is already rated, and the condition's worse. They want to make a claim for increased rating. The key to remember here is you never do this unless you've got substantial medical evidence that really tends to prove the case. If you just go in and, sometimes a veteran will just file these things on their own. I want an increased rating. Without evidence, what the VA typically comes back with is kind of the parry, if you will. They'll come back and say, you're doing much better. We're serving you with a notice that you're going to have a reduction. So they give you due process, they give you notice, and you end up having to defend them on their old claim rating. To say, oh, my veteran's still at 10%. This is a typical thing VA does now in answer to a claim that doesn't have much evidence. Sometimes even if you submit a claim with evidence, they'll still try to fight you and they'll still try to reduce. So I find myself defending these cases all the time. And that's why I typically encourage my clients, never go into VA with a claim unless you've got decent evidence and unless you review it with your VSO. Right, Diane?
Yes, absolutely.
Okay, now a new claim. Vet has never made a claim for this specific condition before, and the vet wants to bring a claim for this condition now. So that's another type of claim. All claims must be pled with particularity. As of March 24, 2015, standard VA forms must be used. Now in the old days, following World War II, a person could write out a VA claim on a slip of paper. The VA used to joke they could write it out on a cocktail napkin. And if the VA actually received it, that would be a bona fide claim. Not after 2015, March 24, you've got to use the required VA forms. So, and I think that's reasonable. It is important to get notice to VA of the claim as soon as possible. When the VA gets notice, benefits can be paid back to this date. Many veterans will want monetary benefits back to service or when the condition started to bother them. This is a popular request for both claims and appeals. However, benefits can only be paid back to the date the claim was made. Now remember this, if you've got a veteran coming out of the armed forces, apply for benefits within the first calendar year after leaving service. If you do so, benefits are payable to the day the veteran leaves the service. That's the first date benefits can be paid. But if the veteran, for whatever the reason, does not file within that year, let's say they file a year and a day after leaving service, and the veteran wants to go back in time, it's not going to be allowed. One of the ways, the best ways to preserve the veteran's rights while you're kind of developing the claim is to file what we call an intent to file. And we'll talk a little bit more about that as we proceed here. Okay, here we are. Preserve the effective date. This is fundamental. If you're not ready to file what we call a fully developed claim, and I just want to talk to you just briefly, what is a fully developed claim? Well, what it means is you and your client or your client and say their VSO or their advocate are going to sit down and they're going to take a look at what are the elements necessary to prove a case. And so if we're looking at a back condition, and as Diane says, a lot of veterans have back problems, and during the service they typically didn't say a lot about it. Maybe, if we're lucky, they saw somebody in the service before they left. Maybe 2 or 3 times, that's even better. But if you've got to gather some evidence, especially you're gathering evidence about what's wrong right now, because remember, we've got 3 elements to a claim. It happened back in service, and we've got some kind of way to trace that with service medical records, but there's also got to be something that exists now. And so we're going to have the veteran digging for current medical records. It might take some time to do that. We're going to use an 0966, a 210966 intent to file a claim. That's going to preserve your data claim, which means putting that 0966 along with your 2122A, or in the case of my VSOs, with your 2122 and the veteran's DD-214, which is the discharge papers, and you basically have a locked-in data claim. That's very, very useful. It's fundamental in practice today. A couple of months down the road, up to a year, you can have time to develop your claim. You put that in within that calendar year. Always give yourself a tickler on your calendar. Never leave it to the last minute. Put in that fully developed claim. Once it's adjudicated in your favor, it's going to go back. If it's not adjudicated in your favor, you can still preserve your data claim by filing a timely appeal or filing another piece in the 3 lanes, and I'll talk to you about that. The key is to keep an unbroken succession of filings within that calendar year and so on. And I'll try to get into that a little further. If you do that, you can go all the way back, once you win your appeal, all the way back to your data claim. And that can mean hundreds of thousands of dollars of relief for your client in certain cases. Not always, but I've seen it on several occasions. Send it in with your 2122A. You got to specify whether the claim is made for VA comp, pension, or dependency and indemnity. So you've got to specify one or the other. And remember this, if you do file, if you perfect your claim, as we say, only one filing is going to count to that 0966. So you file your 0966, 6 months later, you put in your fully developed claim, and it's got maybe 5 or 6 conditions. Those are the only conditions that are going to go back to that original filing date of your intent to file. If you want to preserve another filing date, you'll have to file another 0966, say the day after that. He wants to develop some more cases. Okay, but it won't count on this one. I hope that makes sense. You must perfect this claim within 1 year of filing your intent, or the effective date is not preserved. That's fundamental. That's the key. Remember, before you file anything, you must have an honorable or general discharge from active duty or National Guard or Reserve service. If you're National Guard or Reserve, you've got to have an LOD. Or you've got to have contemporaneous medical records, contemporaneous police report. Those are really tough uphill battles. The key is to have a line of duty. If a Guards member is saying, yeah, you know, I hurt my back putting up shelter halves. I hurt my back lifting in a warehouse. And I'll ask them, did they execute a line of duty investigation? Did you report that to your command? And typically, the Guardsmen will look at me and say, what's that? So they're becoming more educated these days, but a lot of Guards members will say, I never even knew what a line of duty was. But it's very important if they've got one in their file, and you take a look at their personnel file, it should be in there. Maybe in their medical file as well. Should be. Remember the 3 legs of your claim, okay? Before you actually file a perfected claim, remember, it happened in service, conditions still exist now, and there is medical evidence of a connection between service and present condition. That's the only way you will prevail on a claim. And when you get your feet wet and you get in front of a Board of Veterans Appeals judge, the judge will harp on these key things right here. These are the elements that need to be shown in order to have service connection. So if you remember this now, and you remember these are the things we have to do, it's really common sense to work with your client. It's like nuts and bolts. Because what you're doing is you're helping your client to understand, yeah, you were in the Marine Corps and you hurt your back. I understand that. And I believe you, because a lot of times there's nothing in the record. I believe you. It's within a year of getting out of service. If that's the case, you tell that veteran, get to a doctor now and start being treated. Any chronic disease that manifests within a year of leaving service is presumptive, right, Diane? So you want to kind of work on those things. But these are the real fundamentals that you have to have at the beginning, and when you get in front of an appeals judge, it's the same thing. So it's basic nuts and bolts to have your client really develop medical evidence with his or her doctor. Okay, here's the forms. This is a forms-based practice now. You've got to have the required forms. Fill out a form 21526EZ within the year of the, so you filed the intent to file. Now you're going to perfect that claim with a 526EZ within a year of filing that intent. VA will acquire any and all federal records. That's a key. So you don't have to go out and find federal records from federal hospitals, etc. It's useful for development if you can to have all that. You really should have it. But it is true. They will pull these things for you. But it's kind of like shooting blind. That's what Diane's saying. Yeah, you want them records.
They're not pulling the entire Social Security file anymore. If you have someone with Social Security disability, they're only pulling the medical records. So get a copy of that Social Security file and submit the whole thing.
Yeah. And again, if you're filing, personally, I like to see what I'm filing. I like to understand what the records say before I file them. So if you can get your hands on federal medical records, if your client can get their hands on them, you should analyze them along with your client and maybe along with their current practitioner. The way you do that is get a release of information. A lot of doctors don't have time to talk to you though, so you're often going to have to rely on your client having a therapeutic relationship with that physician and then later getting that doctor to present you with an opinion. But the VA, in theory, will get most medical and service records. But you're required to develop all the other evidence and submit it with the claim, including all private med records, any other private records supporting the claim, including employment, voc rehab, or other similar types of records. You've got to have all those up front when you file that 526, right there with your packet. That's why we call it a fully developed claim. All required VA forms, for example, excuse me, if your vet has combat-related PTSD, you're going to want to work with them on the 210781. That's a stressor statement. Now, I like to have my clients work with their therapist on that stressor statement. And the reason is basic, that if you open up a door, it's pretty hard to close it at the end of the session. So if your client decompensates and you're not a therapist, you may want to walk them over to mental health after you've talked about this stuff. And you can certainly trigger flashbacks doing it. So I personally like to have the veteran work with their psychotherapist, if at all possible. If the therapist tells them, no, go to your advocate, I say, okay, we're going to schedule a time to work on this form, but I want you to schedule time with your therapist that day. And I take this stuff deadly seriously because we all know we've got high suicide rates among veterans. I really believe in the value of decent psychotherapy for our psychiatrically disabled veterans. So don't take this lightly. If you've got to talk about stressors, at least give the vet a chance to work with their therapist on it. That 0781, it's going to ask specifics. Where were you at? Who was wounded? Who was killed? These are key pieces that really are the ground to discuss in psychotherapy, not generally otherwise. But as default, I often end up talking with them about it. And so some skills that you can utilize with your client, and I do all the time, is if they're really agitated, I don't have them leave right away. We get up and have a glass of water. And of course, research shows that if you keep your brain a little bit hydrated, you can calm down a little bit. Another one is this one right here. We call it the karate chop point. I've been with veterans and we're getting ready for appeal, and the veteran gets into kind of a loop where they just keep repeating themselves over and over again about a stressful event. And you can look at your client and say, try this with me. And sometimes that little bit of energy movement will just snap them out of that loop. One of our psychologists in town taught me that, Dr. Sakai, but it's extremely useful. But I don't presume to be a therapist. I hope you don't either. But I look for ways to kind of let my client kind of jump out a little bit, if possible, have a drink of water, walk around the campus a bit, and be ready to walk them over to mental health. I'm at Tripler, so I've got the luxury of taking them to mental health triage. That's why I say, if you're going to talk about psych issues, you probably want to schedule a time where your client can actually have access to their therapist if you're really going to open up these doors. Okay? But that's a key piece. You're claiming PTSD, you want the 0781, or in the case of sexual trauma in service, you want the 210781A. Both those things really call for a psychotherapist, in my opinion. Do not include, these are releases of information. This is very important. Do not include forms 21, 4142, and 4142A. This is a request for VA to get non-federal records. And if you submit these things, it means you've not submitted a fully developed claim. The reason you'd want to have an FDC, a fully developed claim, is you give VA all the evidence they need to solve the case. You give them everything, with the exception of certain federal records that they agree to get.
Well, here's the question. How long are they taking now not to do claims that aren't fully developed?
I couldn't tell you that. It certainly does take some time.
One of the reasons we're telling you this is they can take years.
Oh, they can. Yeah, absolutely. They can. So she's right. If she's asking a rhetorical question, it's like, yeah, if you submit this, they will take their time with your case.
And really years.
Yeah. So it behooves you to have a fully developed claim. And as far as I'm concerned, we don't call the appeals this, but any appeal you file should be fully developed as well. You should have all your evidence. You don't want to go to appeal without evidence. If you have to gather it after you perfect your appeal, you can do that. But don't go before a judge without your evidence if you can possibly avoid it, because you will not prevail. So developing your case is fundamental. But these forms say, oh, go out and get Dr. Smith's records, Dr. Jones' records. Go out and get these records, VA. And VA will do that. But as the good lady says, it might take years to do it. You don't want that. Okay, so just remember that, because the VA will send your client these forms. And your client may think, oh, I have to fill those out. And maybe they'll mail them in themselves. So you want to kind of catch them and say, no, we're not going to submit those. I want you to get those records for me. You also want to file all statements needed from all sources. Many times, let's say you got a sleep apnea claim, you're going to definitely want the testimony of other people who lived in a barracks with that soldier or Marine or sailor. Somebody who spent time and can talk about things they saw. Now, never have a lay witness give a diagnosis. They're not qualified. Never have a lay witness say anything about medical terms. Have the lay witness discuss precisely what he or she saw or experienced. That's good testimony, and those lay witnesses are completely competent to testify to these things. Also, it's terribly important to have your client, the veteran, write about what he or she experienced. They are completely competent to testify about what they experienced in the armed forces. But again, don't have them give a diagnosis. That just kind of leads the court away. It's better to talk about what they actually experienced physically, mentally, etc. So, but all these statements, if you're preparing a claim, you're going to want to submit. And people are probably thinking, well, what kind of statements am I going to need? It could be almost anything, depending on the fact pattern. I mentioned sleep apnea, where you want to talk about symptomatology in service, symptomatology after service. Of course, you're going to have to pair that with a medical diagnosis, probably from a private provider. And it can be the same with almost any kind of claim, and there's so many fact patterns, we're just not going to get into it. But you're definitely going to utilize statements to back up what the veteran is saying, and especially the veteran's own statements. I can remember a claim for PTSD that I put in many, many years ago for a vet. And a long story made very short, he was a combat medic in Vietnam. And they had denied him a couple of times, and we had reopened the claim. And finally, when he got to my office and we sat down, I said, well, did you ever tell your story to the VA? Did you ever talk about what it was like in the field as a combat medic? And he said, no. So we spent probably half a day together, because again, I opened up some doors, and some pretty ugly doors. And I typed out as he was talking to me, and we took plenty of breaks, and we got a good narrative, a good long narrative. And you know, that's one of the few cases in my life that the VA decided that claim based on that narrative. He did have a diagnosis, but they had been denying. Once they read what he had to say, and he did have a combat medical badge, they connected him. So theoretically, your veteran statements are really the foundation. And remember, sometimes the VA will underrate what your client says. And I'm not saying they're bad, because we really have an excellent VA right now. But sometimes in that adjudicated process, your client will feel like he or she has really been marginalized. And my answer is, you are completely competent to testify what you had, and a judge will respect that. And time and again, Diane or I get in front of the Board of Veterans' Appeals, and we win our case much based upon what the veteran has to testify, their credibility as a combat veteran, their credibility as a victim of sex abuse, etc. So there's a lot of things to be said about really developing what your client has to say, and that's get all your statements in at the get-go if you can, if you possibly can. But this advice also holds true for preparing for your appeal. Everything I've told you here, you use the same kind of drill when you prepare for an appeal. And you may well get the case at the appellate level. You'll never have this developmental level at front. And in fact, it wasn't developed adequately by whomever did it. So you'll use this kind of developmental logic in order to develop your appeal as well.
I'm glad you added that. That's actually really good advice. So since I do mostly appellate work, you want to look in the file. A lot of the time you'll find that there's a lot of stuff not there, and you're going to develop it. You're going to get the statements. You're going to get the medical records, the non-federal medical records that were never got before.
That's right. And I've got people that work with me. I've got some really excellent counselors. I could talk all day about them, and I'm not going to do that. But I've got people that develop claims that have such a skill at investigation that they will find things in public records that really reinforce what a veteran is saying. It takes time. They've got to dig. There's so much you can do to develop a case. It's really only limited on the time that you have, and time is a key constraint for all of us. That's why I also want to emphasize to you the idea of motivational interviewing. If you ever pick up a beautiful text, if you're wondering, how am I going to interview these people? I'm not a psychologist. You don't have to be, and you don't ever want to be a therapist for them. You want to send them to a competent therapist. But you want to understand how to work with patients, with clients, and these are medical patients. Get a book called Motivational Interviewing for Healthcare. It's written by Miller and Rolnick. They're psychologists, and I think there's another colleague there with them as well. It's a small little paperback. Miller and Rolnick's first book, Motivational Interviewing, is about this thick, beautiful text for counselors. I was a social worker before I was a lawyer. So I'm really into this stuff. But the reason I'm telling you is, you get that little book, it's all about simple ways to work with your client that help you let them help themselves. Because your client has to have ownership of their case. If your client doesn't actually go to see their physicians, or if they don't actually go out and try to gather things that you need for the case, you'll never have a chance to prevail. And you can't do it all yourself. There's no way you can do all of it yourself. So your client has to own his or her case. And motivational interviewing for healthcare will just kind of give you some insights. It might just help you key them in. So scope that book out if you're interested, but the key is your client has to be invested, at least somewhat, in the case. One of the key assessments I make at the beginning of a case is my client ready, willing, and able to assist herself? If not, who are we going to get to help her? That's a fundamental question for you as an advocate, because unless you have an awful lot of social work time in your practice, which you probably don't, I know I don't, you're going to need somebody to assist that client. And if they are so disabled they cannot help themselves, then we're going to have to look for some community resources that might be able to assist them. So, but the key again is we're trying to gather in evidence, information, so that we can prevail in a case. And the challenge is veterans are often denied for benefits because they didn't speak up in service. It's taboo to speak up in the armed forces. I don't know how many people have told me over the years they just took Corman's candy when their knees hurt, when their back hurt. What they mean is they took ibuprofen, they took other NSAIDs, kind of medicines that, I'm an old search and rescue guy from the CAP side. You know, if you're hurt and your leg is really stiff and you don't think you can walk out of the field, you take a few tablets of ibuprofen, you probably can, but you don't want to do that chronically. That's what you do in the service, is you get treated by your medic. It's never reported, and you tough it out. And anybody that runs to sick call is probably not going to get promoted much. So unless it's a traumatic injury and you had to go to the hospital, a lot of times things won't be documented. If you have the good grace of seeing that veteran before she or he gets out of the service, you can advise them. Make sure and see the clinic at Makalapa or at Hickam or wherever else they're at before you get out. Make sure and get some treatment before you get out of the armed forces. We don't always have that luxury. But what we're trying to do here at this level is get the veteran to dig for whatever evidence he or she may be able to come up with from the past, and also from current doctors. I'm sorry to belabor that point, but I want to make sure you can appreciate we're trying to portray the veteran's story here. We're trying to really show the truth. But again, for military service members, the truth is usually obscured because the mission overrides everything. The team overrides everything. And so when the service member doesn't report what happened, it's understandable. Okay. The instructions on the 526Z, they're extremely useful. The VA is getting really good at mapping out how to work these things. Okay, now the VA is supposed to decide a fully developed claim in 180 days, and they're doing an okay job. You know, they're coming up with some decent decisions, and they're doing it pretty quick. Now, we don't always agree with them, and that's why we go to the appeals process. But I've got a lot of respect for the personnel currently in the VA at this local RO, and we're getting a lot of decent, legitimate development, and we've got a lot of good management there who are really above board. So I'm confident that 180-day mark really is a good mark with the present VA. Okay, claims for increased rating. That's already got a service connection, but the condition's more severe. Remember what I said, you always want to go into this top-loaded with all the evidence you need, because if you don't, you're probably going to get a proposal to reduce. You might even get one anyway, so I tend to go to battle thinking I'm going to get a proposal to reduce. So I got to make sure I've got foundational evidence if I can. You know, if I don't, I'm going to have to find it afterwards. So 526CZ, and develop it as you would for any other fully developed claim. To be successful, severity must more nearly approximate the criteria for the higher rating, and it must be based on facts, generally med evidence, not considered in the prior rating. Practitioner's tips. Examine the higher ratings for this condition. You can find that in the Code of Federal Regulations. And see if the medical evidence would show the veteran deserves an increase. Now, we all know that two doctors may have 3 opinions. It's just like lawyers. So medical evidence can sometimes really be on both sides. But if you're reading that evidence and it looks pretty clear and you can match up that criteria, well then you can go for it. You can go for an increased rating. But again, be ready to prove what you've got, because VA loves to go for proposals to reduce.
Also, I would add to that, surgery can be traumatic, even when it works or even when it helps. And you'll get veterans that want to increase their rating because they've had surgery. You need to look really close at the records and see if it actually got worse. If it didn't get worse,
don't go for it.
Don't let them submit it.
You have it, because you're going to definitely get a decrease then. They do
Yeah.
arthroscopic knee surgery. It's supposed to help, and of course it does. And the veteran thinks, oh, I've gone through this trauma, I need an increased rating. If the vet applies on his or her own, the best thing you can do is talk to the vet and counsel them, go ahead and let us remove that claim before they adjudicate it. We've done that on several occasions. Another classic example is coronary artery bypass graft. Let's say the veteran's rated at 50% for congestive heart failure, and the doc says, you know, you need to go in for a bypass surgery. So the veteran calls me up and says, I'm going in for a bypass. I'd like you to put in a claim for an increased rating. I say, well, sir, the purpose of the artery bypass graft is to make you better. Yeah, but I'm going to have my chest cut open. And when we talk about this, and I'm not trying to mock him, that's what I kind of hear. Yeah, I'm going to have a terrible surgery. I might die. I'm going to be praying for you, brother, but I think it's designed to make you better. So until we see those stats, until we consult with your doc, and we look at ejection fraction and all the other pieces that they want to look at, we don't want to apply, because it's probably going to get you reduced. So those are the kind of things you have to really worry about.
And we're talking about proposed reductions. You want to be careful. I know you've seen them too. There's a lot of proposed reductions, and they're on things, it'll make your head crazy.
Yeah.
I've got one, she's someone with an amputation, and they decided her phantom limb pain had gone away. She's in a wheelchair, and her phantom limb pain hasn't gone away.
Exactly.
I had another one. He was less than a year out of service, traumatic brain injury, couldn't take care of his own kids, and they decided that he'd gotten better and they're going to reduce. I know you've seen them too.
Yeah.
So you want to be really careful with these things, because you don't know what you're going to get back.
That's right. And we're not going to get into this too much, but remember, if you do get a proposal to reduce, there's key ideas. They're going to have to show a pattern in medical records of improvement. It's not just one exam. They're going to have to show consistent improvement over time. If they can't do that, it's probably not going to meet any criteria to reduce. So you can defend these cases. Also, if the person's over 55 years old, the department really shouldn't be moving to reduce. So we can use things like this. But the real defense is don't apply until you really think you've got decent evidence. It's very hard. The line between paternalism there, again, telling your client, your client has the right to file what he or she wants to file. But at some point, we sometimes have to differ with the client and say, well, sir, if you want to proceed in this way, for example, what if you've got a client with 100% prostate cancer, and after surgery, there is no more prostate cancer? Now, the only thing I can get that veteran rated on is the residuals of prostate cancer, and that's typically urinary frequency. And there's a table. Let's say 40% is a classic evaluation. 40% for urinary frequency of less than every hour. So that means you have to use the restroom less than every hour. That's worth 40%. But let's say my hypothetical client goes in and files an appeal. I want my 100%. I had my prostate removed. We have to sit down with the client and say, well, you know, this appeal has no merit, sir. I cannot defend you on this appeal. I cannot prosecute this appeal because I can't prove that you have active carcinoma. After they listen to that, they say, yeah, but I want to appeal anyway. Because, you know, sometimes among the latrine lawyer community, you know, the people who just kind of talk to each other, they feel like it's like going to Las Vegas. You know, just why don't you try? But as an advocate, I don't have time to just try. There are certain issues where the oral testimony alone of the client will work, and that's appropriate. But say in the case of prostate cancer, you've got to have articulable medical evidence, and for 100%, you're going to need active carcinoma. I'll sit down with the client and say, you know, I can't continue to represent you. If you really want to prosecute this, I don't have the resources to do it. But I can help you get rated as high as possible based on your residuals. Oh, what are they? That's the way you kind of open up a client counseling door with your people. Half the battle in this work is client counseling, right, Diane? It's listening, it's repeating back that you understand, you hear what they're saying, and then it's trying to work with them to show them what's possible. And also having an eye open to what they really want, and sometimes actually going with that if it's even plausible. So it's an art. But I wanted to touch on that briefly. Okay, the procedure for these claims is similar. Let's take a look. Veterans Disability Claims, pension, and DIC. Okay, it is similar, but they are different. Okay, disability pension. Remember, this is the wartime pension. If you served during a period of war, and for contemporary vets, it's from like 91 on into the future until Congress sets a date. So virtually every person who served on active duty from 91 on is a wartime veteran. That's very useful should that veteran become disabled for non-service connected reasons. And here's a stopgap measure that I often use. My client wants service-connected benefits. It's going to take time to develop that claim. But my client is living on the streets. She has no visible means of support at this point. She hasn't gotten her SSI yet. She's trying to get that. She's living in homeless shelters. She has no income. She says there were X, Y, and Z conditions that she got in service, but we're working on developing that case. A stopgap measure is a 21527EZ. We're going to apply for wartime pension. We're going to get her poverty level subsistence right now. And in the future, if I can win that compensation claim, then she's going to get the balance between what she already got on pension for her back pay, the difference between compensation and pension. That could be substantial money. So while we're pending compensation, if my client or your client lives in poverty, go for wartime pension. At least that's an option. Now for DIC, dependency and indemnity, remember this is for survivors of people who died of 100% service-connected condition or a person who died of a service-connected condition. Say they were rated for heart disease and they died of heart disease. It's one of the causes of death on the death certificate. That spouse is eligible for DIC provided that spouse was married for at least 1 calendar year to the decedent veteran. To the veteran prior to their decease, obviously. Okay, what to expect after filing? Now you've got a due process notice. The Constitution, of course, as we know, is the governing document. It mandates due process of law. The APA is the foundational law that really runs what VA does. We're not going to get into an APA class here, but the VA operates within the context of the Constitution of the United States and the Administrative Procedures Act. Section 5103 basically explains what evidence the VA has acquired, what evidence the VA still needs. That's a key. They have a duty to tell the client what's needed. And it's very useful. It also contains a form asking you whether or not you will or will not submit more evidence, which you must or you should return, I should say. It's very important to respond to this letter. Send as much, if not all, the evidence VA requires to substantiate your claim. So that 5103 notice, that due process notice, once you file a claim fully developed, they're still going to send you a 5103. Now, theoretically, when they made the fully developed claim, there's a box on your fully developed claim that you check that says, this is all the evidence that I have to submit. Nevertheless, the VA, I think, is wise to wear both a belt and suspenders in this case. They're still going to give you your due process notice. So no way can the advocate come back later and say, you know what, we were denied fundamental due process. Instead, you get a clear letter outlining the evidence as we just talked about. That's really useful to you and your client. Okay. The next thing that's probably going to follow is a comp and pen exam, compensation and pension exam. This is a medical exam VA uses to gain medical evidence. Can it be service connected? You know, whether claim can be service connected. And 2, if yes, to what % should it be rated? So the doctor is going to talk about whether there's a nexus to service and what's the severity. Now, it's ultimately for the rater, the VA rater, to decide what the % is, but it's going to weigh heavily on what that doc had to say in terms of objective medical data. Everything the VA does, in theory, should be based upon objective medical data. The best advice to give the vet is to be totally honest, but do not be pushed beyond or outside of what is true. A hearing specialist may try to convince your veteran, and hearing is a common problem for military members in tinnitus. They may try to convince them that, are you sure you always have ringing in your ears? Well, it's really easy for people to underrate or deny that. So you should really sit down with your client and tell them, if you've got ringing in the ears, if you've got a medical problem, stick to what you've told me if that's the truth. And when they say, yeah, that's the truth, John, okay, then I want to make sure you understand people are going to try and get you to change what you have to say. And you might just want to be nice to them, but you can't. You just got to be polite but firm. You know what's wrong. Here's a classical example. Now, people in the armed forces have been taught to be polite and to be respectful. What happens if a nice physician is there and she's examining you, and after she's done, maybe she examined you, maybe she didn't, she sits down and she's writing on her tablet, and all of a sudden she drops her pen, and you've got back problems. Now, if you're a gentleman or a gentlewoman, you might bend down and pick that pen up. I suggest to you, and I suggest to my clients, do not even make a grimace. Do not even look at that pen. Let the doctor pick up her own pen. Because oftentimes they think they're Sherlock Holmes. And they're going to write that your veteran has complete range of motion based upon bending down to pick up that pen. So they'll try tricks like that with you. They'll do various things. And I'm not saying it's bad, it's evil. I just think your client should be aware that people like to try those things with them. Now, I can think of a person that was supposed to move a given digit on his hand, and the C&P doctor told him, do it until you think you have to go to the hospital. Well, I'm here to tell you all that your client doesn't have to move any further than he or she can without substantial pain. Once you got the pain, you stop moving. Right, Diane? Absolutely. Stop moving. Because, you know, I've been before an appeals judge on a case like similar to that fact pattern, and I've got my client rated higher based on the injury they got in the C&P exam. So, you know, I mean, this is problematic. Some of these doctors, you know, they're not regular healers. They're not regular practitioners. They're in a business. Now, again, I don't want to denigrate anybody. VA C&Pers, I think they're hit and miss. They've got some real professional people. They've got some others that I just disagree with fundamentally. It's the same with the private docs, with the QTC and others. So you just want to prepare your client, speak the truth. Don't allow anyone to make you move beyond what you can comfortably do. If that's range of motion and you can't lift your shoulder any higher than this without terrible pain, you don't lift your arm any higher than that. Those are the kind of things to share with your client. And also, never to allow a person to convince you to deny what you've already disclosed that you have. So just remember those tips on the C&P piece. That's the C&P exam. Don't be pushed beyond or outside what's true. For physical exams, stop moving. There you go. We got that. Mental exams. This means the vet should not agree to or say anything that's not 100% true, no matter how much verbal pushing or prodding occurs. If he needs to do so, he should be silent until he's able to collect himself. Now, some of these C&Pers for psych issues, they love to go afield and they love to ask the veteran about trauma they had in childhood. Oh, didn't you have a bad childhood? Didn't you have this? Didn't you have that? You know, I think your veteran really doesn't have to disclose anything about their childhood. I'm not saying to conceal anything, but really this exam's primarily about the military. So if they really want to go afield, you can tell your client, you don't have to disclose anything about when you were a kid. Yeah, I went to high school, I joined the Army, okay? But I feel as though some of these forensic examiners, they want to try to go fishing for some other explanation. But the fundamental truth of war-related trauma is, and you can argue this in your pleadings, that the veteran was fully capable and admitted into the armed forces as a whole person. They went to war, and for whatever the reasons that they experienced, they came back a different person. There were traumatic events, and but for those traumatic events, they were not the same person. And you can support that with evidence from family, et cetera, without ever diagnosing a condition, but by having the relatives, the friends, the coworkers talk about how fundamentally different this veteran was after she returned from Iraq, for example. So don't allow your client to be pushed. Tell your client they don't need to be pushed. They need to be polite, they need to listen, and they don't have to respond to everything if they don't feel comfortable. Right, Diane?
Exactly.
The rating decision, the next thing you get a C&P, your client, and you should at least receive a rating decision. And by the way, if you're an advocate and you pass your TRIP training, and we can talk a little bit about that at some point, you pass your TRIP training, you will then have access to the case management system for VA. It's called VBMS. You should also, do you have access to case flow yet for the Board of Veterans Appeals?
No, I don't. I'm
We're working
eligible.
on that.
Yeah.
Okay, so theoretically, you should have access at least to the case file called VBMS and through your electronic systems. And then in the future, as we're still trying to negotiate this, so that you'll also have access to the appellate system for the Board of Veterans Appeals. So that means you can get rating decisions, for example, on VBMS, should be mailed to you as well if you're a record, counsel of record. Rating decision, this is the admin decision, promulgated under the Administrative Procedures Act and the rules, etc. Administrative decision that grants or denies benefits. And of course, that's going to be per 38 CFR, the rules actually promulgated by VA and the underlying statutes. If the veteran does not agree, there's a 1-year statute of limitations to file an appeal. Now, we talked a little bit about legacy appeals. There are a few cases still out there that might get some pleadings from the old system. And I tried to talk about that a little bit. And certainly I can be a resource person for you in the future if you should get a legacy claim and you need to find a way to navigate that. We can talk. But I want to talk a little bit now about the modern system. Any decision that you receive dated after February 19, 2019 are going to be subject to the 3 lanes of the Appeals Management Act. Okay? So I want to kind of describe it this way. We call them lanes. Appeal, notice of disagreement to the Board of Veterans Appeals, that's the only one that's really a bona fide appeal. These 2 here, these are further lanes of adjudication. The reason I didn't teach this CLE, and Diane and I didn't teach it last year, is because they were still promulgating the rules. And we felt that we wouldn't go forward with a legacy appeals CLE. We wanted to make sure and give you the full AMA so that you can really understand the modern appeals process. And I tell you the truth, I had to practice this for a while and really get involved in it with my counselors and our clients. Now this is pretty clear. This really is kind of a neat system. It's different than the legacy process, but it's what we've got. So there's 3 lanes, higher level review. Let's just look here. Okay. We're going to talk about supplemental claims first. That's the middle one. So if I go back, supplemental claim. Let's look at this. Supplemental claim, the old reconsideration and reopened claims. Now I don't expect that you know those 2 terms of art, but I'm going to try and explain kind of what this means. This is an adjudicative lane. You use this to continue a case within that year of a decision. That's going to be what we call a reconsideration, effectively, okay? You're filing additional evidence that lets the VA say, oh, we hadn't seen that before. Perhaps we can decide your claim now. Okay? There's also another piece to this. There's also the idea of a reopened claim. Now, a person can reopen a claim anytime, at least try to, based on new evidence. We call it, in this case, we call it based on new and relevant evidence. Something that would tend to either prove or disprove your case. So, what if the claim was decided over a year ago, but now your client comes in and they want to file a claim, and they say, well, yeah, they denied me for my back, I never appealed, I want help now. You can also use the 9-5 in order to reopen the thing, okay? But the kicker is, if it's over a year from the date of denial, unappealed denial, your date of claim only begins from the date of filing that supplemental claim. So if your decision is less than a year old, you go all the way back to your original date of claim. That's why you really want to be timely. You want to really have yourself a tracker on these cases and make sure you're aware of your statute of limitations dates. That's fundamental in these cases. So let's say you're going to go with a supplemental claim. It's based on new evidence. Fill out a form 200995, which you've got in your packets, I think, right?
No.
We didn't give it to them? Okay. You can pull them up on the internet easily. Just type in at Google VA 200995. You're asking VA to take another look at a claim previously denied for service connection. This includes a claim you're bringing under a new secondary service connection theory that you might have brought for direct connection. You must have new and relevant evidence to tender a supplemental claim. Okay, so it's new evidence, never submitted, and relevant information that tends to prove or disprove an issue. If the claim is tendered before the prior appeal period expired, it goes back to the effective date. That's what I was trying to tell you. Formally called reconsideration. If the claim is tendered after the prior appeal period expired, the claim goes back to the date of the supplemental claim. And the threshold on either of these is you've got to have new and relevant evidence. Again, that's something that tends to prove or disprove the case that they've never seen before. Okay. Higher level review. Now this one you don't submit any new evidence. But it's very useful. You fill out a form 0996 instead of an 0995. You are asking VA to take another look at a claim previously denied for service connection. You're given no new evidence. The key here is you can have a conference with the decision maker, and it's often very helpful. I've got some workers in Oahu and in Kauai who win these things all the time because they're really good with the regs, with the CFR, and they'll get a conference with the decision maker and they'll show them precisely where they made a mistake. And if you're nice about it, especially, you treat them well and you show them what was wrong, they'll fix it. So this is kind of a nuts and bolts way that you can cure a problem, nip it in the bud.
I think a way to put it into context is, for my veteran where they missed his arm, I'll file this, I'll talk to the decision maker, I'll point to the evidence. I just did the same thing with a different vet where they were trying to argue that my vet was employable despite the fact that she'd missed all this work. It didn't make any sense because her last job had written a letter about the reason that she was let go is she missed so much work, they donated all their leave, and finally it had just run out and she had to resign. And I pointed that out to the decision maker and we won. So this is actually really fantastic. Yeah. This is a really fantastic thing to use when you're looking at it and noticing they completely missed this. You just get on the phone with somebody and you tell them what they missed and you're done.
Yeah, it really is useful. So use this as a troubleshooting method. And if it doesn't work, you can always file a supplemental claim based upon new evidence. And if that doesn't work, file your claim to the Board of Veterans' Appeals and file your notice of disagreement. And that gives you time to gather evidence because you can submit evidence all the way up to the hearing. You can present evidence in your BVA hearing, and you can present evidence up to 90 days following that hearing. So it's actually very useful. Never fail to go to the Board of Veterans' Appeals if you've got a colorable claim. If you think you've got a case, even based on oral evidence from the veteran, and let's say you feel like the VA really didn't help your client develop his or her claim, you've also got an argument then to remand, to say, hey, VA didn't do his job. We're going to talk a little more about that as we go. Okay, NOD, this is the one that I love. Now we use a 10182 instead of Form 9 in the old legacy appeals process, which is still in play maybe the next couple of years. 500,000 cases. We already talked about it a bit. I'm not going to give you too much more legacy stuff. If you need to talk about a legacy appeal, if you're unclear about what kind of appeal you have, give me a call or give Diane a call, and we'll talk about that fact pattern, and we'll help you kind of navigate that system if need be. Board of Veterans' Appeals, BVA appeal. This must be filed within 1 year of the VA denial. Now remember, that 1 year of a VA denial, that includes the time that you kept the clock running filing a higher level review. So let's say I got a denial on, say, February 19, 2019. Okay? Let's say that I filed for a higher level review. The next one, I said, hey, I think they made mistakes. So I filed my higher level review. About a month and a half later, I had a conference with the decision maker. She didn't agree with me, and she denied. So I got another month and a half ran. My client said, well, you know, I've got some more evidence. I'm still going to the doctor. And I looked at the evidence, and I say, well, you know, I think maybe it tends to show what you're asserting. So we file a supplemental claim. What if that supplemental claim takes another 6 months? The statute deadline is good. From the date that I filed that supplemental claim, or to start out, from the date that I filed the higher level review, I've got up to a year to file another piece to this puzzle, either a supplemental claim or a board appeal. So I filed it within that year, now I got a supplemental claim. Once I get a decision on that supplemental claim, if I don't get what I need, I've got a year from the date of that supplemental claim to file my appeal with the Board of Veterans' Appeals. Okay, so that's the way we keep the clock running, we keep the statute of limitations active, and we preserve our date of claim, because that's what we really want to do. You never want to drop your date of claim on these cases, because some of the key things for your client is you preserve that date of claim, and if it does take several years, the payment goes all the way back to the date of the claim. That's substantial. I can remember clients over the years, and Diane's had numerous as well. They will call me up and they'll say, John, there's $50,000 in my bank account. Somebody made a mistake. And I'll say, well, let me check. And I'll go into VBMS, the electronic data case management system, and I'll look and I'll say, they just promulgated a decision and you've got money. Can I use it? Answer is yes. And then I give them some advice on don't tell anybody you've got money and so on and so forth. But that's real. That's real. And we see people's lives change. I have people who've told me, I have a lady who got DIC after a long drawn out appeal period, and she got substantial back pay, and she was living in poverty. And she said to me, I can eat every day now. That was the reality for her. This is some of the best law you will ever practice, my friends. And so preserve that date of claim. You're going to get them some back pay, and your client is really going to move up in the world and be able to have some stable housing and a decent life. Okay, so board appeal. These are my favorites. I love the Board of Veterans' Appeals. I consider them to be among the finest judges I've ever been before. I was in law practice starting in about 95. I've been in front of a lot of Superior Court judges back in Washington. I've been an Indian lawyer. I've worked in tribal courts. I've done administrative law things. These are outstanding judges, and so are some of the other judges I've been before, but these people are awesome. And they really are veteran-centric people. They are highly motivated. And if you want an appellate judge who's also a fact finder, you want to go to the Board of Veterans' Appeals. And I'm not going to give you a lecture why I think an appellate court should also be a fact finder, but in this case, they are. So everything you learned in law school is down the tubes, which is fine with me, because the best citizens in the United States have access to the best court system, in my opinion. The legacy appeal was an even better system, but this is still doggone good. Board of Veterans' Appeals, BVA appeal. File them within 1 year of your last denial in your unbroken chain, which I just discussed with you. This appeal goes on a 10182. How do you remember that? Well, the 101st Airborne and the 82nd jumped into Europe on D-Day, or before that. So I remember it that way. It's a darn good set of numbers, in my opinion, and it really stands for veterans and honor. So I love that number there. This appeal, it's incredibly rare that not having a hearing would be your best choice. You've got options. You could, if you really, really wanted to, if your client really wanted to, you could choose an option that they only take an argument on the briefs. I would never do that. I would always present evidence in front of a judge if I could. And some of you may say, I don't have a lot of experience in front of judges. Well, here's the good news. If you're a person of good conscience, and if you can ask the most basic questions, if you need help in learning how to formulate some of those questions, call me up, we'll talk. But the rules of evidence do not apply. In my opinion, the rules of evidence were rules designed to allow sophisticated people to manipulate an evidentiary system. The rules of civil procedure are even worse, in my assessment. And I've seen people use those rules to the best of their ability, and if you're good with them, you can manipulate the outcome of a case. Well, in these cases, you cannot, because those rules do not apply. So there's no sophistry involved whatsoever. You're actually going to present facts before a judge. Now, as Diane says in this note, you typically don't want to just have an argument on the briefs. You want a beautiful brief, but you also want to present oral evidence and evidentiary presentation in court. Now, these cases are all going to be by video. There's no more traveling judges. I've still got probably hundreds, and Diane's probably still got hundreds of legacy cases. We're going to have a travel board with a traveling judge once a year. Those are great times. One year, I think I called Diane. I said, Diane, I've got 38 appeals in 1 week. You think I can do it? She said, yeah, I think so. And you know, that was a tough week. For me, I had 38. My colleagues had, probably one had 12, another had 10, another had 5, and so on and so forth. But I had 38 of them. And I did get through, and the secret to doing that was I did a lot of prep months, at least 30 days before. So I got everybody in, we went through all the materials, we went through all the questions, formulated the questions, everybody knew what was on the same page. No questions when we get into court. Everybody knows. I know what I'm going to ask. My client knows what I'm going to ask. I know what they're going to say. I never ask any questions that I don't write down. That's a fundamental rule of court presentation. Never ask a question that you don't know the answer to.
Your client will come out with things you're not expecting.
Yes, yeah. You
no
don't
matter
want that.
how prepared you are.
You really want to understand the whole nature of your client's evidentiary testimony. But these are beautiful cases. 10182, attach additional pages laying out your argument. This, by the way, is perfecting your appeal. It's a term of art. When you file at 10182, you are doing one of the last acts you need before you can get before a federal judge, administrative law judge. Additional evidence can be submitted to BVA before and up to 90 days following your hearing. That's beautiful. I can't think of a good advocate who wouldn't choose this route, because how do you know what kind of evidence is going to come in within 90 days? And judges are happy to see it. They're happy to see that evidence come in. They're overjoyed, in fact, because they want to find for the veteran. That's the beauty of this court. All you got to do is give them proper evidence. You know, certainly, obviously, legitimate, appropriate medical and other documentary evidence, and that's what you're going to do. The BVA will either grant the claim, deny the claim. Now, you may have a whole bill of claims. I mean, there may be 4 or 5, maybe 10, 15 issues, but within that 10182, within the 4 corners of that, you might have 5 issues, let's say, before the board. They might grant some of them, they might deny some of them. They might also remand. So remand the case to the regional office. Regional offices are defined as the local jurisdiction, the local office. In Honolulu, that's the Honolulu Regional Office. Okay? There's a RO, a regional office, in all sorts of major city and rural areas around the United States, and Diane?
Yes.
We're arguing that VA failings duty to assist, and there's any number of places you can show that. So that's something you want to keep in mind. Later appeals. Okay, now, Diane, do you want to talk about this piece? Because you're a CAVC woman.
I can. I wasn't going to say a whole lot about it.
Okay.
So I think some of it you covered. So there's being denied at the BVA. You can file a motion for reconsideration. John's talked about winning a couple of those. The other thing is, it's a delay process. So if you're an attorney, sometimes this is actually something that VSOs can't do, is go to the Court of Appeals of Veterans Claims. You have to be an attorney. So sometimes this is where you pop into it. You have 120 days from the BVA denial to file in the Court of Appeals of Veterans Claims. Sometimes, I'm sure you attorneys are aware, the person shows up to you on day 119. Sometimes it's just a little more convenient to file that motion for reconsideration. There's always the chance you'll win it. BVA doesn't like to grant them, but it at least gives you 120 more days to figure out what you're going to do before the court and to go ahead and file. So the Court of Appeals of Veterans Claims, what I don't like about the VA practice, all the courts are actually in Washington, D.C. The nice thing is, most of the time with the Court of Appeals of Veterans Claims, it's going to be on the briefs. They don't do oral arguments for the most part. So this is doable from here, and I've actually won every case I've brought. Knock on wood. So CAVC is actually doable from here. So I've won every case, so every case has gone back for further development to the RO. If you don't win, you can appeal to the CAFC, you can file a motion for reconsideration or review. There's different tactics you can take. The CAFC, the Supreme Court, of course, you have to pop up in DC. So I don't know that any of you are going to do those from here. You can if you want, but with those, you actually do have to appear on the East Coast.
Okay, and I just want to say this as just a practitioner's point. You will love doing appeals if you really keep your eye on it. This is the best area of practice I've ever done. But remember this, keep strong records of every case you have. Make yourself your own record-keeping system that lets you chart statutes of limitation, timelines for filing. If you chart things out, and again, you might get a decision with 2 or 3 different pieces out of Board of Veterans Appeals. Denial, finding, and remand. It's pretty simple to deal with as long as you chart them out, as long as you got a map. Check your case every 30 days. If you touch every appeals case you have every 30 days, you check the status with VBMS, which is the electronic case file, and you're aware of your timelines and what your client needs to do and what you need to do, you will love this appeals process, and you will find that you will prevail time and time and time again. So it's a great system, but fundamentally, you've got to be a good record keeper, and you've got to be a good watchdog, and you've got to be good at asking yourself, did I do everything? It doesn't mean become paranoid. It just means check yourself every 30 days. If you do that, you probably won't go wrong, and you will end up loving the system and finding you can do it really, really well. Okay. In all claims and appeals, develop the claim. This is the bedrock of all practice in veterans law. Make legal and factual arguments in writing where appropriate. Keep it short and reliable. Don't law the court to death. You can cite laws, you can give analysis. Be heavy on the facts if you've got facts, but don't law the court completely. Obviously, you're going to write a brief, you're going to give legal analysis, but be short and readable. In developing the evidence, read the decisions and evidence, but don't forget to listen to the veteran at length. That's your key person. You will figure out from this what you need to have in the claims file. Consider statements from the vet, but also family members. This is key. My son was never the same after he returned from the Iraq War. He used to go out at night and enjoy things with his friends. Now he stays at home in his room, and so on and so forth. He was a different man when he came back from Iraq. That's essential. That's good, strong evidence. The veteran's own testimony. It's fundamental. Military buddies. Often you hear about buddy letters, and that's a term of art. It means a statement from a third party, okay? military buddies that were with you in the field or with you in training or other places. Those are key people. You know, I won a case one time based on a man who was in the field in Vietnam as an infantryman in 173rd Airborne, but his 214 specified he was a clerk. Now, I know a little something about airborne units. It's the same as a Marine unit. Every person in an airborne unit is a rifleman. I don't care who you are. Well, before they'd let him be a clerk, and he was also a jazz musician, before they'd let him play guitar for him down in Vietnam, he had to go in the field with a 170 or an M79 grenade launcher and a pistol and be the grenadier for an infantry platoon. And he saw plenty of action. Well, we couldn't prove that. Finally, he found his company commander, who was retired colonel by that time. Colonel wrote him a letter saying, I remember him. He was a musician. Sure enough, we proved the case. So letters from people who know you, your CO's letters, if the CO is still alive, extremely useful. Letters of officers, they're gold. Letters from colleagues, they're gold too. Current friends who see what's going on in your life, don't ever get lay people to diagnose though. Let them talk about what they see. That's all that's required. And again, they're completely competent to testify about everything they saw, experienced. Never diagnose unless you're a doctor. Employers, co-workers, anyone else who knows veteran may have observed or knows something. If you're going for unemployability, to be able to talk about the problems that a veteran with post-traumatic stress, and this is a typical fact pattern for me. I've got lots of vets with PTSD from these current wars and from Vietnam. They have trouble on the job when the symptoms manifest, and they become really problematic. To have a boss be able to talk in a concise way about what that veteran acts like on the job and the fact that he had to be let go because he just won't cooperate with anybody, and et cetera, that information is fundamental in these kind of claims. If appropriate, file a Form SF-180 for the veteran's personnel records, because these are unlikely to be in the claims file. It's quite true. So your SF-180, I'm sorry about the distraction, my friends. Your SF-180, we've got some window cleaners out there for folks on the video in the future. Your SF-180 basically is a request to the National Personnel Records Center for military records. You can ask for the service medical records. You can ask for the service personnel records. Sometimes now the VA will do its development job and they will be in the file. If they're not in the C file already, you can indeed search for them. You can ask for them. Okay? Personnel records, service medical records, they are very useful. Sometimes, especially like Air Force records, Vietnam era, they won't show boots on the ground in Vietnam. I don't know why, but they don't. I have actually fought cases where I've ultimately prevailed when the veteran goes through their military gear and finds travel orders, sending him TDY, temporary duty, to Vietnam. I've won a case based on that, because they found their travel orders in their old field jacket. That's really useful. I've had others. A veteran was in a very special unit in the Air Force, classified stuff. The only indicator was small arms expert. That indicated in the Air Force there's something special about this fella. He went to Vietnam. He was on the ground indeed several times, but it wasn't in his 214. But he had a printout from the Pentagon on one of the old Sparrow Univac. If you ever, I'm kind of old. These old Sparrow Univac computers, they were big, long computer readouts. Well, he had a personnel readout with his name and social security number on it, and it specified Vietnam service. We took that and used it and proved he was in Vietnam. So those kind of things are very useful if you can obtain them. And sometimes the veteran may have things that the personnel file doesn't have. So don't rule that out. If they've got an old military box or they've got old military gear, they may well have some records in there. They just don't remember it. Private medical records, that's fundamental. You know, and in fact, the best thing again is to engage in legitimate care with a licensed physician or psychologist, and to be able to have treatment and to have articulable opinions about how does this relate to service. And that's reasonable. Now the VA sometimes will tell you, you know, it's not our job as doctors to give an opinion about how it relates to service. It's just our job to treat. It's the first time in my life. I've been around court systems since about 1982 in various roles, social work and law. I've worked with physicians throughout my career. I've never had a physician refuse to give me an opinion on a legitimate case until I got to the VA. So that's a policy issue. Okay, and I'm not trying to put them down. I'm just saying it's like pulling teeth to get a medical opinion out of the VA. That's why private medical records are so very useful. And that's why when this good gentleman mentions the Mission Act, mentions the idea that you can actually access, in Hawaii, you can access private medical providers through the VA medical provider by saying, hey, I want a private doctor for this. There's no reason that they have really to deny you. Maybe they'll hem and haw, but especially for psychology, they should allow you to have that. And I think the regs pretty much back us up on that. So we should be able to get our people access to Mission Act. It is kind of difficult, but I think it's very possible. You need private medical records if at all possible. Private employment records, especially when you're dealing with aberrant behavior on the job, unemployability, things of that nature. Ask the veteran what he has from his time in service. Travel orders, there's what we just talked about. Because whenever you travel, whenever you go, you have to have orders allowing you to do that. If you don't have orders, you're AWOL, you're absent without leave. So travel orders are essential, and people keep those orders. And like I say, I've won cases based on travel orders that are 50 or more years old. So that's very, very useful. And sometimes you'll jog your client's memory. Oh yeah, I might have something. And then they'll look and they don't find it, and then later maybe it turns up. A nexus letter from the veteran's doctor, that's a key. Remember, if you remember almost nothing else from this, you've got a beautiful portable memory here that'll let you jog everything you need to know. But remember the three legs of a claim. Something happened in service. Something still exists now. There is a medical connection by a competent practitioner who can articulate why. It's not just, I think it's as likely as not that, Mr. Smith has a back problem as a result of military service. We actually need to articulate, we actually need to see why does the doctor have that opinion. If a doctor can provide that, that is really the foundation of a VA case for relief under compensation. Be a counselor. Assist the vet with statements. Prepare him or her for C&P exams and hearings. Get copies of C&P exams and review them, because you can scrutinize them and show where there's lots of holes. And you can do that with almost every C&P exam. These are often one of the most important pieces of evidence. My friends, you want to say something here?
Yeah, no, we're running out of time.
I know
so
we
I
are.
figured
I
figured we should check and see if there's any questions.
We're going to take lunch, but yeah, who's got questions? Anybody?
I think we've probably worn them out. That was 3 hours of pretty intense stuff. There are 2 more slides on when not to bring claims. We did touch on that throughout. Don't worry about it. We did touch on that throughout.
Yeah,
surgeries.
Right.
So the best advice given to me, an attorney is not a bus. You don't have to take all comers.
That's right.
VSOs, it's a little different. With us, assess your cases. I know I've got a guy who served in the 80s that wants to bring a claim for Agent Orange.
Right. And even as VSOs, we don't take illegitimate claims. Now, there's a fine line between what a person can testify to orally and a plausible claim. So it's an art. But I thank you for your interest in this area. If you choose to practice in this area, this is an outstanding agency, Volunteer Legal Services. They'll actually give you an opportunity to get your feet wet and actually represent people. And you're representing some of the best citizens we have. So I encourage you to do this. And if you need somebody to talk with a little bit about this stuff, give me a call.
And I'll second that. I was actually in Senator Hirono's office earlier this week and heard that there was this great nonprofit that they help get case files for.
Yes.
We love our office directly.
Yeah. Well, they are not unhappy about that fact.
That's great. So thank you again for your interest. And if you want to come back to the last 2 hours, it really is worth your while. We're going to be talking about practice pretty much. And I think you can't go wrong if you talk a little more about practice and you ask some questions and you look at fact patterns. So it's going to be a pretty cool time. I invite you all to come back if you wish.
And you also can't go wrong if you go to lunch, so have a good one.
Take care.